This is The High Road with author and registered psychotherapist, Dr. Marlene Bizub. Dr. Marlene speaks to the heart of people who need to be lifted up and get out of the muck and mire that often accompanies major life changes, such as divorce or separation. Dr. Marlene will aspire to help parents of divorce to love their children more than they hate their ex, and to learn to take the high road. So please welcome the host of The High Road, Dr. Marlene.
Good morning, or good afternoon, or good evening. This is Dr. Marlene and George, and you're watching The High Road on the Dr. Marlene YouTube channel. We have a great show today, but I guess I should welcome you first, George. Welcome, George.
Thank you, Dr. Marlene. Great to be with you. Good morning, at least in our time zone.
Yes, exactly. But we do have a great show today. I'm excited because, first of all, I think it's going to be really helpful and useful to our audience. I hope so, anyway. But I think it's stuff people really don't know. And I think it's stuff that, and I call it stuff, but information that people really should know. If you are going through separation or divorce or going back in over parenting time, what we used to call custody, then it's stuff you need to know, information you should have. The first thing we think, George, it, is get an attorney and get a tough one. That's the first thing we think. But there's a lot of options, not that you don't need your attorney, because certainly people do. I mean, there's parts, even if I help people work out parenting time and we work it all out, there's still stuff they need their attorney for financial and property issues and all of that stuff. But the first thing people think, though, is litigate, not just attorney, because attorney's legit, but they think litigate. They think it's going to be a battle, it's going to be a fight. And of course, that's what our show is about, is hoping that people see this does not have to be a battle. It does not have to be a fight. Even if you are really angry at each other right now, or whatever you're feeling towards the other, we can get through it without contentious litigation. So I'm going to let you take it from there and comment on that, since that's your world.
Well, I am a firm believer that parents do not litigate their way to a healthy co-parenting relationship. Litigation tends to breed more anger, more fear, whereas there are good alternatives to be had, such as mediation, and working with a mental health professional to identify what's best for the children.
Yes. Yes. And especially when it comes to parenting time, certainly you have to talk to your attorney, but I think sitting down with somebody who can help figure out parenting time from the mental health perspective, or maybe I should say the family perspective, child experts, family experts, not necessarily legal experts, other than we have to incorporate that into what we do. But that's where it's my job to make sure I'm educated about things that are going to go into the parenting plan, what the court expects to see, what we don't have to have in there, but more importantly, things that many people leave out of the parenting plan that will be extremely useful. I've said this before, that people will come in to work out a parenting plan because they think they're really close, and we just want to sit down with you and, finish it up and just work it all out. And they'll come in with 6 or 7 items and they'll leave with 22 or 23. Now, you might think that sounds like too much. I mean, people, I know, but people might think that sounds like too much in there, but it's not. It's the detail and specificity that people need in their lives moving forward to avoid all these little fights that we have along the way, because we don't have a clear and detailed parenting plan.
Yeah, I think that's true. And what I always tell people is when you have an issue, the first place you turn to for resolution is your parenting plan. So it's critical that the
Well,
parenting plan be thorough and comprehensive.
yes, yes. And just like little things like, we've talked about this before, but children's belongings. You and I know how many arguments ensue over children's belongings. No, I bought you those shoes. You're leaving those here. Well, we have a rule about that, and that's not what the rule says. And so it's those kind of little things that if you just put a statement in the parenting plan about the children's belongings, and there are a couple of exceptions. It's not like you have to let anything and everything go to the other parent's house. There are a couple of exceptions, but by and large, children's stuff is their stuff. And so, just little things like that that parents don't know. And when I talk to them about, okay, we've agreed on the holiday, we're going to exchange it this time. Okay, well, who's picking up or dropping off? Oh, we didn't talk about that. Okay, well, come Thanksgiving, come Christmas, you're going to argue because one parent's going to assume the other's dropping them off and they're in the middle of cooking a dinner and they find out that no, they were planning on you picking them up. And this might sound like petty stuff, but it's not. It's huge. Arguments like grow, let's just say. They multiply and they grow in intensity over these kinds of things because it's a holiday and you're stressed and you've got people coming over and now you got to figure out who's picking up and dropping off because you didn't bother to address that to begin with.
Well, I think it's critical that those types of details be fleshed out and included in the parenting plan. Sometimes we need telephonic text type of
Mhm.
instructions in there, but it is the first resort when there's a dispute, and so we can't have it totally comprehensive. It would be the size of a New York phone book when they had phone books.
Right, right. Yeah, good point. And, when you mentioned texting and things like that, so often we'll have some type of app just because they're terribly useful. The Talking Parents or Our Family Wizard or Civil Communicator, those are communication apps that co parents can use. And it'll be in the order that they're going to use that app. Well, then when it's kind of urgent because it's the holiday and you haven't figured out who's picking up and dropping off, you'll get a parent who says, he or she texted me and we're supposed to only communicate through Talking Parents. Well, life doesn't work like that. I mean, I'm sorry, it just doesn't work like that. And so if you anticipate that and have a statement in there that says, for most things, parents will use Talking Parents or Our Family Wizard or whatever it may be. But for more urgent matters, the parties may text one another. That's all you need. But you get parents who get upset that day because they don't want to be bothered and they say they're violating the court order because all it says that we will communicate through is the app.
Well, a concern that I have, and I don't really address it, I think you address these things, is the more parents squabble over their children, the more the children tend to withdraw from the parents. And
Absolutely.
and then where do they turn? Where's that vacuum of authority and leadership and love and affection? Where is it filled in? Because it's not going to remain a vacuum. And
No,
so I have concerns that the more parents squabble, the more their children withdraw from them.
absolutely. And that's a great segue into addressing the different types of professionals who work in family law cases, because that's really our topic today. And this was a great setup to just dive into that because the obvious answer, well, maybe not so obvious to some people, but having a therapist for the child, just a counselor they can talk to, might be a school counselor, might be outside of the school setting, but someone they can talk to. So when things like this happen, they can tell their therapist, counselor, whatever you want to call it, that mom and dad fought. It made me feel really uncomfortable. It ruined my Thanksgiving or my Christmas or whatever. And then that professional can come back to the parents and say, did you realize how profoundly your arguing on Thanksgiving affected Bobby? Because Bobby's not maybe going to be capable of telling them himself.
I think that's true. And when children enter the teenage years, then they're going to turn to someone somewhere, peers or other adults, and we hope that they are a good influence, but they
Yeah.
aren't always. And so we
No,
want parents to parent their children and not squabble over them. We don't want the children to be the focal point of anger and frustration and litigation.
right. Well, and in a scenario like we're talking about, it's a holiday and they're arguing, often who kids will talk to is a grandparent who's there for the holiday. Well, that can be good or that can be really bad because it can be that grandparent who says, oh, yes, your father or mother, the other parent has always been like that. They've always argued about everything or, whatever, but they can cast shame and blame onto the other parent, whichever parent is not their child. And so that's not always the best person. Now, don't get me wrong. We've talked about this before, George, and I know you and I both feel this way that grandparents and people like that, other people in children's lives, can be a great asset. And we don't know what we would do if we didn't have them in this situation. But they can also do a lot of destruction.
I think that's totally true, and I was surprised to find out when my son was an adult. He said that when things got unbearable, and I don't know why, I still don't know why, but when things got unbearable at home, he would go over to his grandparents, who lived close enough that he could do that, and so he would escape, if you will, to his grandparents' house. And I never knew that until he was an adult. But it illustrated
Yeah.
for me what an asset to children grandparents can be.
Yes, yes, they can. And especially if you get a good one, they are invaluable. They really are. Um, but going back to the therapist, I believe every child that goes through their parents' divorce should at least go and talk to someone once or twice. If they don't feel the need, fine, but at least have them go a couple of times to establish a relationship with a counselor. So if something comes up that they do need someone to talk to, you've got someone. Because in the moment, kids aren't going to want to disclose things or talk about things, vent to someone that they don't know. And so I think you've got to establish that person in their life. That's why school counselors are great because the kids will see them, often every day at school. Maybe not talk to them in their office every day, let's hope, but they'll see them and it's a familiar person that they can talk to.
I think that's also true for the parents. The parents, if they
Mhm.
have someone they can turn to and talk to, different from going to the attorney and going back to court over something, that's a great outlet for them. And that's where some of the different professional roles come into play that we're going to talk about a little more today.
Yes, yes, and I totally agree. And whether it's a therapist or a PCDM or a divorce coach or those things that we're going to talk about here in a minute. Them having someone is crucially important too. And just as I feel every child should have a counselor, I feel every parent should too. Because when they don't, you and I know what happens. They end up sounding off to the children or in front of the children. It may not be to the children, but if they don't have that person to talk to who's a professional, that they talk to away from the children, they're going to end up talking to a friend, family member, neighbor, coworker, someone like that. And it often is done in the presence of the children or where the children can hear them.
Yeah, and I think that's destructive as well for the children to hear the parents arguing and fighting, particularly when they're the topic or the subject of that argument.
Right, right. And it hurts their hearts to hear mom vent about dad. And so adults need a private place to do that too, so that kids aren't hearing negative things about the other parent.
Yeah, I think that's true, and there are so many options today to going back to court that really, uh, if parents haven't exhausted those options, I really think they should do that first before they look to litigate. Uh,
Yes,
be, they're going to go to a court of loss where somebody loses, somebody wins, or they perceive they win, but really, typically there are no winners in that situation.
mm,
If the judge, I've heard judges say if both parties are upset with my ruling, then it was a fair ruling, which is a little cynical, but they really do feel that way at times.
right, right. Because you and I both know there's never been a parent who walked out of the courtroom and felt like they got everything they wanted. It
No,
just
not at
doesn't
all.
happen. No,
No, not
no.
at all.
And they will focus on the things they did not get, which is why it's a system of loss. It really is, because they're going to focus on what they didn't get the way they wanted it. Never mind the 10 things that went their way. That one that didn't go their way is what they're going to focus on.
Yeah, that's true, and they're going to want to renegotiate or relitigate those things. The first thing out of their mouth oftentimes is, "Well, let's appeal."
Yeah.
And
Yeah.
very, very rarely does an appeal in a divorce case result in some sort of overturning or reversal of the trial court's ruling, because the law is set up to vest or give the trial court judge a lot of discretion as to what he or she decides with regard to the divorce case, parenting issues, financial issues, and so forth.
Yes. Yes. And they don't realize that often what they're, quote unquote, appealing is not the judge's opinion, not the ruling, but just whether procedurally they did everything correctly. Isn't that right? Isn't that kind of how that works?
Yes, very much so. Just to file an appeal because I disagree with the judge is a recipe for failure of the appeal.
That's what I thought. That's something I've learned over the years of working in the family court system is you don't get to challenge their opinion. You get to challenge if they followed proper procedures and things like that, but their opinion will stand. And often what happens is they'll be told to do something maybe different procedurally, but the outcome's going to be the same. Their
Well,
opinion's still going to be their opinion.
the issue may be presented as abuse of discretion when
Mm.
someone is trying to seek to overturn a trial court's ruling in a divorce case. And that is a very, very high bar, high standard to meet, because by design, the trial judge has a great deal of discretion.
Right, right. Okay. No, that's something that I mean, I hadn't heard it exactly in those terms. So that's very helpful for me to learn.
Well, it's a very high standard to meet abuse of discretion. It has to be a pretty outrageous ruling to meet that standard of abuse of discretion.
Okay. Okay. Good to know. Well, I don't know if it's good to know, but it's good to have the information. Let's put it that way. Okay. Well, we are going to dive into the various roles when we come back, but first we're going to take a quick break. This is Dr. Marlene and George, and you're watching The High Road on the Dr. Marlene YouTube channel. We'll be right back.
What if there were a super tiny device that could diagnose the brain and is smaller than a single human hair? What if you could see inside the brain to help an epilepsy patient during surgery or to help the fight against Parkinson's disease? Dr. Patricia Broderick is proud to announce the Broderick Probe, a biomedical and electronic breakthrough. Imagine a probe to help with the understanding and potential cure of brain-related diseases. To learn more, listen live to the Easy Sense radio show with host Dr. Broderick. And to help support the Broderick Foundation, please go to easysense.com and learn how, with your help, we can fight these horrific brain disorders. That's easysense.com to learn more and help support the Broderick Foundation. Author, radio show host, and coach John M. Hawkins reveals strategies to help gain perspective, build confidence, find clarity, achieve goals. John M. Hawkins' new book, Coached to Greatness: Unlock Your Full Potential with Limitless Growth, published by iUniverse. Hawkins reveals strategies to help readers accomplish more. He believes the book can coach them to greatness. Hawkins says that the best athletes get to the top of their sport with the help of coaches, mentors, and others. He shares guidance that helps readers reflect on what motivates them, rediscover and assess their core values, philosophies, and competencies, find settings that allow them to be the most productive, and track their progress towards accomplishing goals.
Welcome back. This is Dr. Marlene and George, and you're watching The High Road on the Dr. Marlene YouTube channel. Before we went to break, we're talking about the various professionals that work within the family court system. And I think there's by far more than people know. They have no idea. I've even had people be unaware that evaluators existed. Or any kind of professional that works in the court system, except for the obvious ones. So we're actually going to start with you, George, and let you talk a little bit about what I think of as the more obvious ones. So take it away.
Well, one of the first things that a person encounters if they can't get along after the case has been filed, the first judicial officer they'll encounter is usually called a magistrate or a sub-judge, an under-judge, but usually a magistrate. And that is a judicial officer who has limited authority, but certainly authority to enter an order that gives the parties their marching orders, if you will, while the case is pending. And so oftentimes that structure is helpful. It can calm things down. It can start educating the clients on the likelihood that they're not going to get everything they want out of a judge. So they see this magistrate to begin with, and he or she has, as far as the parties are concerned, all the authority that they need to enter that order to guide the parties while the matter is pending. And so that's typically going to be a magistrate. Your final order or your trial is going to be conducted by the judge typically. Once in a while, attorneys will agree to have the final trial or final order heard by a magistrate, and that's okay. There's nothing wrong with that. But typically it's going to be the judge with the full authority of a judge that handles the final order of the trial in the case. Mm-hmm. So that's really the first formal authoritative people that litigants or parties are going to encounter. There are others. There are certain attorneys who perform a specialized function, such as a guardian ad litem or child's legal representative, where the court is going to appoint, usually it's an attorney, to represent the children's interests and to speak for them in the court, because they're not going to bring children into the court to testify and say, well, what do you want to live, who do you want to live with and why? And that just doesn't happen. No. And I know sometimes parents are surprised by that the children are not going to be permitted into the court or into the court process. But so in that case, if there's a need, then the judge is going to appoint typically an attorney to serve as the child's legal representative or a guardian ad litem. And the guardian ad litem has a lot of authority because he or she is seen as a neutral who is solely interested in what's best for the children, de-escalating the case, the anger, and so forth. So those are principal actors that they're going to see, of course, the attorneys. Um, and then I think I turn it back to you as far as evaluators are concerned.
Yes, I'll be happy to take it from here. And evaluators are a good place to start because this is what, in my opinion, after 18 years of doing evaluations, I think people want to stay away from. Sometimes they're necessary, and you and I know that. But sometimes it's just one parent wanting more parenting time than the other parent. And sometimes they have legitimate concerns about the other parent. Sometimes they're not that big of a deal. It's more the parent trying to win in having more time with the children than the other parent. But as far as evaluators go, we have, I think, no, I'm not sure you did mention this, sorry, chi- um, child and family investigator or CFI. And then we have parental responsibilities evaluator, which is just a more extensive form of the CFI. And we refer to that person as a PRE. And those processes, especially the PRE, which, as I said, is a more extensive form of evaluation. And what I mean by that is they're going to talk to all of you, you and your children, more times. It won't be once or twice, it'll be, 4 or 5 times. Everyone's different. And every case, I'm sure, is different and requires a different amount of contact with the family members, but they'll usually talk to them more. They'll allow more collateral sources of information. And so these are outside people who know the family, know the children, and can just speak to what they've seen and what they've heard and what they think is best for the child. And it can be quite intrusive. Like they come into your home, they talk to your children, they go to the school, which I still do in the roles that I fill now for the court, but go to the school and talk to the children. And I always, in any role, defer to the child. If they don't want me to come to the school, I'll honor that and I'll find a different way to talk to them when they aren't at mom's home or dad's home. But the evaluation is terribly intrusive. If it's the more extensive PRE, there often are psychological evaluations conducted on each parent. And let me tell parents something: what's good for one is good for the other, for the court. That's the way the court views this. Is if you think one parent needs a psych eval, you better be prepared to get one yourself. Or if they need an alcohol and drug assessment, then it's good for you to have one too. That's the way they look at that. And so you want to watch what you wish for when you start asking the court for all these various, DV assessments, domestic violence assessments, and alcohol and drug evaluations, and psychological evaluations. And biggest thing, well, I think the biggest is the stress, but it gets very costly to have all of this done. I mean, people spend thousands, thousands. And I don't mean 2 or 3 thousand, I mean 20 or 30 or 40,000 sometimes having evaluations done. And so after years of doing that kind of work, George, I decided that there are better ways. And so now I'll get into the two that are my favorite. And that is the PCDM, which is Parenting Coordinator. And some states have, along with that, Decision Maker. So sometimes you can just have a parenting coordinator, depending on what your state allows or what you need. And that's someone to just kind of negotiate back and forth between the parents, educate the parents, things like that, because we don't expect people to know how co parenting works. But there are rules, and as most of them are, rules of thumb that govern the co parenting relationship. But a lot of people don't know what they are. And the basic co parenting class is an hour and a half, 2 hours long. You are not going to learn everything you need in that length of time. And we also have more extensive classes, the level 2 and level 3 classes, and that will teach people a lot more. But as a parenting coordinator, I can tell you how I work, and that is that I go over those rules with both parents at the beginning of my involvement, and then they know what they are. And that will sometimes, in fact, I joke to my clients that I kind of work myself out of a job by doing that, because once I teach them what the rules of co parenting are, they don't have near as much need for me to come in and negotiate and all that. And then the DM part, the decision maker part, is when we negotiate and we can't reach an agreement, then someone who has the decision maker authority is allowed to actually make the decision. And that decision becomes an order. And you have to follow it as soon as it's issued. And you can have a judge overhear it, hear it and potentially overturn it. But that rarely happens. In my experience, well, knock on wood, I have never been overturned on a decision that I have made. Not that I couldn't be, because sometimes judges just see things differently. But a big part of that is, since the statute says you have to follow it as soon as it's issued, by the time you get into court 2 or 3 months later to have the judge hear it and potentially overturn it, you've been doing it for several months, and the judge isn't going to upset the apple cart now. They're going to leave things as they are. So that's part of it. Why we rarely get overturned. Yeah, let you jump in and comment on those.
I think the parent coordinator decision maker is an invaluable asset in a case. Uh, People might be surprised sometimes how petty things are that people want to
Mhm.
go back to court for. Somebody's late 10 minutes all the time to pick up or drop off. They want to go back to court to the judge. The judge doesn't want to hear that.
No,
You know?
no, they don't. And the other value, well, two things. It's a 2-year appointment. So an evaluation takes 2 or 3, maybe 4 months. But having a PCDM actually work with you for 2 years, it is invaluable, because often by the end of 6 months or a year, they're good to go. And I rarely hear from them. I've got I don't want to call them a couple, they're no longer a couple, but two co parents right now that, man, last year I worked with them a lot. And this year we're coming up on the end of my 2 years. I haven't heard from them, I think, all year. And so they learned what I set out to teach them and show them, is how co parenting is done, what the rules are. And then the other thing that I think is invaluable about that role is I can tell each parent the same exact thing that the other parent told them or said to them. And they'll receive it completely differently, because it's coming from me, a neutral person and a professional, not their ex, who right now they're still angry with and, have really negative feelings towards. It's just a matter of having the right person approach a parent about something. And the wrong person is, at this time, the other parent.
Yeah, I think there's no question about that. And if people, if they fight or litigate, all that tends to do is precipitate more fighting or more litigation.
Mhm.
and it rarely results in an outcome that both parents are satisfied with, that they find fair. And I think it takes a lot of courage on the part of a parent if there's a parental responsibility evaluation. We used to call that custody.
Mhm.
um,
Right, right.
but uh, and that parent is advised in the evaluation to have less time with the child. The fear that they have of losing their children makes it very difficult for them to accept that they might take a little bit of a minor time role with the children. But
Mhm.
if they're courageous and selfless about it, uh, then they can accept that. Not easily, but they can accept it.
Right. And a lot more so talked with when it's talked to with them, and boy, that was hard to say, by someone like myself. It's just much easier for them to accept. Especially those parents who have always been the one kind of in charge of the kids. That's all going to change now. And when the other parent says, well, you don't get to be in control all the time anymore, they don't receive that well. When I say, there's some benefits to not having the kids all the time, you get some time to yourself, you get a break. And there are two parents, and God gave us two parents for a reason because it's a lot for one person to do. I say things like that, and they receive it completely differently.
I think one of the most difficult cases to deal with comprehensively is a case where there's an infant.
Yes. Yes.
And
Yes.
I'd be interested to hear your experiences with when there's an infant involved.
Oh, yes. Those are really tough because the primary parent, when they're a baby, which typically is mom, just because they're breastfeeding often and things like that. Um, And back in the day, women were the only ones who got time off, maternity leave. Now, many fathers do too. And I think that's pretty standard. But it used to be that mom was the one who got that time off if they worked. And so, um, part of it is I've been with them 24/7 and you're gone most of the day. And when you are here, they're asleep and you don't know how to care for them. But the other thing is, when they are babies, we typically don't, and I mean babies, we typically don't do overnights for the quote unquote other parent. Usually father, but not always. And that gets to be a real thorn in some parents' side because they resent the fact that they can't have an overnight yet. That will come. But developmentally, they aren't ready for it. Babies aren't ready to wake up in two different places. It's hard enough just getting used to the world as it is, but especially to routinely wake up here for a few days and then wake up there for a few days. It's not stable for a child, for a baby. And so, yeah, those are really hard cases, for very different reasons on each side. But, that's the kind of stuff parents don't think about. They don't think about what it's like for a baby to wake up somewhere else. And I liken it to when we as adults are visiting someplace, we're in a hotel or, visiting family. And we wake up and for a minute we're disoriented. And then we go, oh, yeah, I'm in this hotel in Memphis or, wherever. And, parents can relate to that. And I tell them that's what your child is going through every other week or every few days, depending on how often they switch. And that will often sway their thinking, but they don't know this stuff. And that's why it's crucial to have somebody really work with parents.
Well, I think for a lot of parents, that endangerment standard for modification is daunting. And
Yes.
so it's not always a fair or great standard in all cases, but it's a very difficult standard to meet. And so I think parents are frightened by that.
Oh, yes. Well, and we need to take another quick break, but I'm going to have you hold that thought and share with our audience what you're talking about because this is important stuff. This is Dr. Marlene and George, and you're watching The High Road on the Dr. Marlene YouTube channel. We'll be right back.
Did you know that your beliefs create your entire reality, but it's the subconscious beliefs that do most of the creating? Belief shifter and life coach Shiraz can help you identify those limiting beliefs and eliminate them, often in a single session.
Like it was almost instant, like I had relief right away.
Creating better health, relationships, careers, and finances. Let Shiraz help you step out of safety and into awareness.
Definitely something's happening. It's like a flow inside. It feels good.
Whether in person or online, Shiraz provides personal coaching, belief shifting. Visit Shiraz at energeticmagic.com or call 416-529-7429. Energetic Magic. Find your greater happiness. Be well. Be aware. Be magical. Author, radio show host, and coach John M. Hawkins reveals strategies to help gain perspective, build confidence, find clarity, achieve goals. John M. Hawkins' new book, Coached to Greatness, Unlock Your Full Potential with Limitless Growth, published by iUniverse. Hawkins reveals strategies to help readers accomplish more. He believes the book can coach them to greatness. Hawkins says that the best athletes get to the top of their sport with the help of coaches, mentors, and others. He shares guidance that helps readers reflect on what motivates them, rediscover and assess their core values, philosophies, and competencies, find settings that allow them to be the most productive, and track their progress towards accomplishing goals.
Welcome back. This is Dr. Marlene and George, and you're watching The High Road on the Dr. Marlene YouTube channel. Before we went to break, George, you were talking about the endangerment standard. And I think this is crucial for people to know about. So do you want to explain what the endangerment standard is?
Sure. For certain modifications of the parenting plan or the parenting order, the person who's seeking modification has to prove that unless the court grants the modification, the child or children will be subjected to significant emotional impairment or physical endangerment. And parents can fight a lot without having physical endangerment, or I think significant emotional impairment probably comes up more than physical endangerment of the children. The other standard is called best interests of the child, and that's a lower standard to meet evidentiary wise in the court than significant emotional impairment or physical endangerment. So the endangerment standard for modifications presents quite an impediment to parents, I think, being willing to accept a lesser time position, knowing that they can go back and modify that reasonably. If they come face to face with that endangerment standard, their attorney's going to tell them that, gee, if you want a modification of this, you're going to have to prove endangerment. That hardens their position more. And it is a scary, difficult standard to meet. And so parents need to be mindful of that when they're constructing their parenting plan, even though it's kind of a negative pall over the situation. It makes it a little more difficult sometimes to have a parent who's willing to accept a little bit less time.
Right, right. And what I often tell parents is what they might think of as endangerment to the court is bad parenting or even really bad parenting, but doesn't rise to that level of endangerment. Because, like you said, that is a high standard to meet, high threshold, I guess you would say, to meet to prove endangerment. And I hate saying this, it hurts my heart to say this, but it's true. It's that old adage of something almost has to happen. Somebody has to get hurt or, really be harmed in some way for the court to consider it endangerment, because parents have a right to raise their children. The other piece of that is emotional impairment is awfully difficult to prove. And most attorneys, no offense, but I think you'd agree, I think you'd be the first to say this. Most attorneys don't really know how to present what is emotional impairment. And I don't think judges know what to do with it or how to perceive it or, receive that information. Like, how do you know when it is emotional impairment? I would think you'd almost have to have a professional come in, a therapist or someone come in and say, yeah, this is emotionally harmful to the child.
I think so. And there are key words there: significant emotional impairment. So if
Mhm.
you come into court and say, my child's upset because mom or dad is doing so and so or acting so and so, that's typically not going to be significant emotional impairment. You almost
Right.
have to have a mental health professional as an expert witness testify as to the repercussions on the child that establish the significant emotional impairment for the child.
Yes. Yes. Because it hurts my child's feelings when his other parent refers to him as fat. Okay, there's a nicer way to put that. It probably isn't the nicest way, but a lot of people are going to hurt I mean, this is kind of how the court views things often. A lot of people are going to hurt our feelings in our lives. And maybe the better approach is to help the child get used to what you do when someone hurts your feelings, because it's going to happen. And the answer isn't always, especially when it is in relation to a parent, to take the child away from the parent or have them spend less time. Maybe again, have a parenting coordinator work with that parent on a better way to tell your child that he's overweight or she is overweight, something like that. But yeah, to prove impairment or, real damage or harm or endangerment is awfully difficult.
Well, and it takes time, I think, just like
Mhm.
in this is just my opinion, but it takes about 3 years for a judge to settle in to domestic cases.
Mhm.
That's my experience. They gain experience at it. They become better at it, more refined in their approach. Um, but it's critical, I think, for the involvement of mental health professionals in the divorce process. And I could tell when I had an experienced mental health professional and when I had an inexperienced mental health professional. So apparently there's a learning curve there too as well.
Oh, there is. There absolutely is. I can attest to that. Yes. Well, I'd be remiss if I didn't bring up one other role, and that is divorce coach. And we don't see them appointed a lot. I don't know that a coach is in the statute, although I have had a judge appoint me as a divorce coach. But I don't think that terminology is in the statute like PCDM is. And a lot of people don't know about divorce coaches. And I did not know. I had worked in the profession 18 years when I learned what a divorce coach was. And I was actually at a conference for National Speakers Association, but I had written my book or was in the middle of writing my book. And I learned that there was such a thing as a certified divorce coach. And I can tell you within 4 months, I was certified because I came back from that conference. When I learned about it, I said, that's the answer to the problem that I write about in my book. And that is that there's a better way than to litigate everything. And I still think PCDM is best because it's recognized by the court. But parents can choose to utilize the services of a divorce coach, either separately or together, and just become educated. That's all it is we educate people we negotiate. It's akin to, or actually almost identical to, a PCDM, but without the decision-making part, unless the parents agree. Parents can always agree, "We're going to allow you to make the decision when we don't agree and defer to your decision." Now, legally, there's no um, teeth to that, no stronghold there legally. But if the parents agree, they'll usually honor whatever they agreed to. And so a coach is an option too. And I even encourage people, because I've had people ask quite often, "Do we both have to work with you, or can just I, because I don't know that my ex will?" We prefer both, but one person can. It's better that one person gets the education and the information than neither.
Yeah, I think that's true. And so much of the divorce process is educating the parent or the
Mhm,
client.
mhm,
And I think that really should start in the initial conference or consultation with counsel, with the attorney. The
mhm,
attorney has to start educating, and hopefully that education process results in a reduction of the fear and anger that the client typically feels, at least when they first appear at my office. The fear and anger were almost universal
mhm.
emotions that were displayed by clients.
Absolutely. I mean, those are the two primary ones that we see. For sure. And also, sometimes I can see the comfort that it gives a parent just to hear me say that I've had a lot of people go through what they're going through, depending on what the specific issue is. "Oh, yeah, I've had a lot of people go through this." "Really? What did you do? How did they resolve it?" And that alone gives people comfort. So I can't say enough about getting a professional involved just to help walk you through this process besides just the attorney. The
Well,
attorney is very important, but we gotta have others.
Well,
Yeah.
and I know that your reputation is impeccable. Court staff is
Ah,
familiar with you, and I have talked to certain clerical people, and they say, "Oh yeah, Dr. Marlene is great to work with." So
oh, thank
your
you.
reputation precedes you, and it really does facilitate the divorce process to have an experienced mental health professional on the case.
Thank you, George. I appreciate that. It is now time to go, but thank you. I appreciate that. All right. This is Dr. Marlene and George, and you've been watching The High Road on the Dr. Marlene YouTube channel. We'll see you next week.
Tune in to The High Road with host Dr. Marlene and gain insight into how to rise above tough circumstances and learn the skills that will help you take the high road in your life, no matter what challenges might come your way, on the next episode of The High Road.